Okay, welcome everyone. This is the call to order for the Chesapeake Beach Board of Appeals. This is March 17th, 2025. We are here today to approve some meeting minutes and then to continue deliberations on case 2023-03. As always, we begin with our roll call. Please answer that you are present. Mr. Paul Doherty.
Present.
Ms. Amy Everett.
Present.
And Mr. Jody Hoonstar. We have a quorum. The first agenda item is meeting minutes approval for our previous meeting of March 6, 2025. Does anybody have issues with those minutes as they saw them?
No.
Hearing none, I would entertain a motion to approve the meeting minutes.
Move to approve.
I will second that.
Body in favor?
Aye.
Okay, we are on to the continuation of case 2023-03 Roddenville Incorporated, Donovan Estates LLC to consider an application from the Roddenville Incorporated, Donovan Estates of 4160 Mears Avenue, Chesapeake Beach, Maryland for a decision on interpretation of alleged error to Article 6, Section 290.23, 290.31, A1 and A6 of the Chesapeake Beach zoning ordinance and Section C309, C310, C311 of the Chesapeake Beach Town Charter. Applicant requests the Chesapeake Beach Zoning Board of Appeals to, quote, order the zoning administrator and planning and zoning commission to immediately commence and prioritize the processing and review of the relevant site plans submitted by the Roddenville, and that the zoning administrator and planning and zoning commission be ordered to apply the zoning ordinances in effect as of January 29, 2021, when the applications were submitted, and for such other and further relief as the nature of their cause requires. Okay. Where we left it off last time, where I believe with two things, and we do not have to go in that direction if the board so chooses. But I think they were good ones, and we can take them in any order. I think, Amy, you had a concern, well, not concern, you were interested in looking at the timing of the appeal and seeing if it fell within the threshold, the number of days in order to be accepted by the Board of Appeals. So that's number one. And number two was Paul had asked us all to get together some questions that we could kind of tick down the list. I have my own list, but I don't know if they're worth reading. I'll happily defer to you, Paul, if you'd like to go through some of yours. I think the idea was good and it helped me consolidate my own thoughts, which I'm happy to discuss. So I guess I'll so not to run over everybody. Paul, you'd had some questions. Are there any of them or all of them that you would like to work through?
Well, I think the first two that I had are the most important ones. And this goes back to the powers of this board as described in the code, the ordinance that institutes this board. First question is, at what points in time was an order, requirement, decision, or determination made by the planning and zoning administrator or a commission that was relevant to this appeal?
Yeah, I'll happily chime in there. I think from my own notes, I'd initially noted two ones that I think could possibly be decision points from the administrator or related to the administrator's duties. You know, there's some specifics there. The first one I think we can discard is the decision on whether or not the moratorium ended and they should have reopened the site plans. I think that's pretty well off the table for me as not a decision point that was made. I think.
Can you elaborate on why you say that?
So I think that I think that the decision was made initially by in response to the engineer, Mr. Woodburn, I think, from Mr. Jakubiak, and that was the decision point. The decision to re-evaluate that, I don't think, or that just doesn't quite fit with what I think the scope of our duties are, or what we're asked to do here. I think the only decision Mr. Jakubiak made that can be evaluated by this board is the initial email response to Mr. Woodburn, and we can put some brackets around that for what falls into that.
Was there a decision made when the moratorium was lifted? Well, you said
Yeah.
you didn't think
I don't think so.
that decision point.
Yeah.
Was there a decision point?
I don't
In other words,
think,
Was there a decision made?
oh, yes, I'm
I was clear my thought.
Oh.
Go ahead.
I don't think a decision was made. I don't think, from my interpretation on how this worked, was that the planning and zoning administrator made a determination, or if he made a decision, it was made at the time as to when he responded to Mr. Woodburn, and that then the moratorium just made that that question never reopened. I don't much know how better to phrase it.
So to clarify, you're saying that Jakubiak's letter of February 5th, 2021
Yes,
was the only response. And that in 2022, when the moratorium was lifted and the request came to re-examine the applications, the response came from Pounds and not the commissioner or the board or
Right.
the Board of Appeals, whatever. So therefore, there was not a decision. Is that what you're
that's
saying?
yes, that is my interpretation.
But that was before the moratorium was lifted. 2022. Moratorium wasn't
Or
lifted.
20, well, there was a, yeah. So
Right. There was a request to evaluate the site plans sometime in 2022.
mhm.
That's when town attorney responded that the moratorium was still in place.
And am I correct in saying when this particular response was the triggering event that caused the appeal? Was that response email from Mr. Pounds?
We have to be led to believe that it was, because during this case and in summation, we have been told that he even says in the summation, there is no distinct act upon which any appeal period could be initiated. So therefore, that's the only thing that's happened in, in the timing of it. So, and I personally don't feel that, well, yeah. I think the only decision that was made was February 5th, 2021, whether it was a lack of a decision being the decision. I think that is the only point in which information was communicated directly about this case, which is also agreed upon by Blitz that was the only communication from either commissioner or the board about it. I think decisions were made by others in the town that have been discussed, but the appeal that we need to examine is what the planning and zoning administrator, Jakubiak, or the board did. That's,
Do you think happened after the moratorium was lifted?
I can't say, we can't say for sure, right? I think we could make some guesses, but I don't think that's,
I don't know that pertains.
and I think there's an argument to be made, not to pile on here, that there are two different interpretations of when the moratorium was lifted. One was once it expired, and the other one is when they got together to formally vote and pass the zoning ordinances. It seemed like they lined that particular vote up. Yeah. Do you think that was that an important point for you?
Well, I'm asking the question.
Yeah.
Whether now, first of all, the moratorium was formally lifted by a resolution. Before that, I think you're implying that it sort of expired by itself, possibly. I'm not sure I agree with that, but I was thinking of the point at which the resolution that formally lifted the moratorium occurred, at that point, the site plans, review of the site plans could have been picked up. Was there some decision made not to do it? Was,
Yeah, that one, yeah. I think that.
I have not seen any evidence. It would just seem to be a lack of action on the part of the zoning administrator.
If they did reopen them at that point, it would have been with regards to the new zoning ordinances, right? I mean, right, so there's a lot of speculation.
I think there's a couple of things going on there, though. Is that was there an application to look at? It was said that no, we're not going to be able to look at these applications. Here's your money. So was there an open application for them to examine after the moratorium? And I think if the case is one, I don't think it's our duty to, I don't think it's within our purview to say if this moratorium was legal, not legal, the duration or anything else. That is beyond our purview. That was done by town council. I don't think that pertains. But if it was illegal, as Blitz has said it is, then to me, it's a moot point as to whether it occurred or when it occurred, because then it just goes back to what happened when the applications occurred and what was the timing of the events after that. If they had 60 days to look at it, what happened in 60 days? If they did, and then 30 days after that, what happened? I think that is what I think is the key of what we're actually looking at. And I think that things may or may not have occurred correctly after that. That's not ours to determine, because the commission did not do that. And if I just think in many ways that is not what the appealable offense would be if we determined there's an appealable offense.
Yeah, that kind of echoes the same thing I've been rambling about for the.
All right, so the second question is, let's presume that the only decision we can rule on or action is at the beginning. Was it in error as a result of a misinterpretation of the code? Decision not to review the,
Yeah, whatever.
not to review the site plans.
I mean, yeah. I think so just to back up one step, this particular instance is difficult for me because I think it puts us as the board in a spot where no one gets a fair shake here, right? Is that the first thing is was there a decision made? Like, did appeal, denial, like whatever, was this a decision point? If we say that Mr. Jakubiak made no decision, then there's nothing to appeal here, right? There was never a decision that's in scope for this board if he didn't actually make a decision.
I thought we kind of agreed that there was a decision.
So hold on a sec. So the second part of that is if he did make a decision, no matter what happens, what date we use for the appealable range, for the timeliness, it's well outside. Like if this date is when the thing happened, it's outside of the appeal is outside of 5 days, the appeal is outside of 30 days. Doesn't matter what we pick.
Correct.
Not just say anyway. Sorry, Paul.
So is your point that it would be moot to talk about whether there was even an error because the timing had passed?
I think we have to,
Right.
but I don't think that changes the outcome. It might technically change the outcome, but
The imposition of the moratorium, does that by necessity mandate that appeals cannot be heard? If, you know, if an appeal can't be heard, then the fact that it wasn't filed is not relevant.
I've seen nothing to indicate that an appeal couldn't have been filed and we couldn't have heard appeals during that time. Permits can't be pulled during,
sorry?
permits and
Yeah,
whatnot
right,
can't be
right.
pulled during an appeal, and different, new construction according to that couldn't happen. But I read nothing that an appeal couldn't happen. So.
Okay.
So, right.
So where are we?
I think we go down our list, which is first, unless someone wants to make an argument for a different point in time, the only decision point we're considering is Jakubiak's initial response to Mr. Woodburn on what date did you say that was? February
5th. Yeah.
2021. And if we believe that that's the only point, did Mr. Jakubiak make a decision in his role as the zoning administrator?
Can we discuss further?
Yeah.
So I think it was a decision. And I think that his decision was further clarified by the fact that they had a meeting, that they discussed these issues, that they had been discussing some of the things that he brought up in that letter. Since 2018, they had been talking about a comprehensive plan. They had been talking about other things. And then they had the meeting February 24th, to which parties here spoke. So I think that it was a decision, and it was a well-stated decision, not well-stated decision, but a clear statement. Whether it was correctly done, or I'm not sure, but it was a decision.
Was it denial of the site plans in a
They weren't denied. They were not ruled on, which is different.
decision?
Right, but at the same time, it wasn't put on hold, and therefore, I would see that as a denial. It's not like, hey, until we can do this, let's go ahead and put this on hold, and
Well,
Put on the shelf.
they were put on hold.
so they just said they couldn't do it. I don't.
It's the same as putting it on hold.
Yeah, I take this as it was a denial and not a clear denial. It was an unclear denial, which is not fair. I don't think anyone would argue.
Well, I do agree that that was a decision made at that point.
Okay, so if that was a decision by the Planning and Zoning Commission, and we agree he was acting in his authority as the zoning administrator. Is it an error? I think that's the next. Am I right, Fred? And that would be the next criteria. Would be a decision was made. Was it an error in interpretation
Of the zoning code.
of the zoning code?
I would say that the considerations that caused the decision was outside the code. It was considerations emerging from the town council. It was known that the town council was considering a moratorium.
Actually, now that I say it, I wonder if we even should get to that, right? Like if it was a decision was made, maybe the next step isn't, was it an error? The next step is it appealable? Was the appeal filed timely? Is it within the stated guidelines that we have here? We might not even need to get to whether or not it was an error in the code. I agree that it's unsatisfying to consider this particular question. If our guidelines state that an appeal needs to be filed within 5 days, 30 days, I think those are the two. And I think the guidance is that we stick to the stricter of the two. within 5 days was an appeal filed. Is that, sorry, before even talking about that, is that the question we should be discussing here?
Well, I mean, what makes something appealable, right? So you have to go back.
So you think this particular, the error comes first?
Well, I mean,
Yeah, I guess you're right. I mean, I guess you can't appeal
well,
without.
but you need to have, yeah.
Fair
So
enough, yep.
I
Okay,
think you need to have it.
sorry, disregard my tangent. So Paul was saying is this an error? Paul was saying it was outside of the code, considering considerations emerging from the town council. Do you have any particular?
It was more operational considerations. I'm not sure how to describe it, administrative or operational considerations.
Can those be considered errors if our job is to interpret the statutes of the zoning ordinance? It's kind of,
Well, the code does have words in it that describe how the commission and administrator should conduct business. So to some extent, those are operational guidelines. But in this case, I don't think that what happened is within, I would say within, I don't want to say this. I think it was more administrative in nature. The administrator and the commission knew that the council was considering a moratorium. And in fact, the commission recommended it.
so if our job is to come through and say the zoning administrator made an error because he did not do this specific article, this specific section, whatever, of the zone of the code, can we say he made an error, right? If he's operating in this administrative kind of gray area capacity.
Well, if the code says that critical area site plans have to be reviewed within 60 days, and they don't get reviewed within 60 days, is that an error? Is that a error of interpretation? Because they weren't reviewed in 60 days.
I agree, but that's yeah, please.
Information is that, isn't it the planning commission which is supposed to complete its review within 60 days of a critical area site plan?
It's listed in there, yeah. Right,
Not the zoning administrator.
right. It's the commission.
It doesn't, so the zoning administrator can take as much time as he wants to look at the site plans and make recommendations?
My recollection, I don't have it here in front of me, is that there's no time limit for the zoning administrator to make a determination on validity of the site plan. The 60-day period we're talking about is, I think, tied to the planning commission. I could be wrong.
Well, in any case, once the moratorium was lifted before the 60 days expired,
You mean it was in place?
it was, that's right, it was in place before the 60 days expired. And I agree that once the moratorium was in place, I think it was out of the hands of both the administrator and the commission.
So it does say in 290-23C3, the Planning and Zoning Commission will review and take action on all Category 1 site plans. So this was a concern I had of mine before, is that the wording of this, I don't think explicitly states that everything has to be done within a certain time period. I think once they've received information, whatever, then they are in that time period. I have not been convinced that the administrator was obligated to get underway. Early on in this whole thing, we were told that the commission had to put in whatever time they needed to get this done in 60 days. That was their job. Their job is elsewhere. This is what they volunteer for. I don't think that this code was written to imply that they had to drop everything and get 5 site plans done in 60 days and to have a determination with all the other pieces and parts involved and all the other people involved in referencing that information. That said, if the 60 days was to be set and we decided there was an error for that, that decision would have had to have been made by March 30th. And if appeal was to be filed because it was not done, whether there was a moratorium or not, brings you to April 29th, 2022 or 2021. And
Well, let me stop you for
So-
a second.
what?
That's assuming that the appeal needs to be filed within 30 days.
Right,
This is
I'm just
crit-
giving the most, whether it's 5 days or 30 days.
But the provisions relating to critical area site plans provide for a 5-day appeal period.
Correct. I'm just giving the most time period given that, like if it's 60 days and if it's 30 days, yeah, right. So then that would be what, April 4th, April 3rd. Yeah. So there is an error if we believe that the planning administrator and commission together, everything they had to do, had to come up with a decision in 60 days.
Here's the wording. It says, Planning and Zoning Commission shall approve, conditionally approve, or reject a site plan within 60 days from the filing of the application.
Which one?
This is 290-23. 290-23. No, I'm sorry, it's 290-25. 290-25, parens 5.
Right. So once the commission is in receipt, right? But it says
No.
upon receipt of the site plan, the Planning and Zoning Commission shall, in 5A, you're reading 5C. In 5A, it says upon receipt of it.
I be skeptical of the interpretation of that.
I think,
Once the application's submitted and the fee paid with the application, I think that constitutes receipt. But in any case, the moratorium was imposed 7 weeks after submission. That's less than 60 days.
okay,
Once that happened, I think the administrator and the commission were obligated to cease any work on those plans. So,
So if I'm reading what you're saying, Paul, is that you don't think the zoning administrator acted in error or error of
I'm not
interpretation?
necessarily saying that. Well, I guess, yes, I guess I am saying that. I think it was, I don't think it was if there was an error, I don't think it was an error resulting from an interpretation of the code.
Yeah, I think I agree with you. Was that a decision was made and it was not an error.
There's several other considerations that, sort of floating around, which may probably shouldn't be part of our decision, but, some external considerations.
Or if you'd like to,
I'm trying to read lips. at
Oh,
the
I'm
same
sorry.
time.
I'm sorry.
Okay.
So one is, the appellant brought up the issue that the moratorium was illegal. I don't think we have the authority to rule on that.
I agree.
I think that's within the bounds of the court. Yeah, I don't think the zoning administrator or the commission, planning commission, have authority to rule on that either.
that's right.
Another point that I wanted to make is that even if we decided that there was an error and we ordered I still question whether, I believe we can tell the zoning commission to review plans like in a certain way. I don't think we have the power to order them to review plans according to superseded code. In other words, provisions that were in place in 2021 that have been since superseded by newer or updated code provisions.
I, th- if it was a normal matter of business where the planning and zoning commission didn't, or the zoning administrator didn't pick up a thing just of their own volition, and then waited, some amount of time, in which case zoning changes happened, I would be, I think, willing to make them use the old zoning code, provided it was scoped within the authority of the administrator in planning and zoning, right? Like if this had nothing to do with the moratorium or town council, if the planning and zoning commission itself made a mistake resulting in harm to an applicant, and the applicant then comes and says, hey, they did this wrong. I wouldn't think it would be that controversial to do it in a case where all of the decisions were self-contained within planning and zoning. In this case, it's a lot of time and it involves the town council and lots of other external folks. So the decision wasn't contained within. I wouldn't have such a problem with that, but in this case, I don't want to do that. I don't think we should do that.
I'm not sure I follow you, but
Yeah, okay, doesn't.
the zoning code is put in place by the commission, by the council and the mayor.
Yeah, maybe it's not possible.
And, once that occurs, I don't think an administrative body such as ours
Good point.
have the ability to override it.
As far as I understand, we only have what is within this book right here, this code.
Mhm.
That's it. We don't have rights beyond that. So we don't have rights to tell every person that we want to what to do. And yeah, I agree with you. The town council sets that.
Amy, no, do you take that as did the planning and zoning administrator act in error at any? Sorry, can you hear me? Did the planning and zoning administrator act in error in your take?
I think that I'm not fully convinced it was an error per se, but if there was an error, I don't believe it was in the interpretation of it. I don't. I was agreeing. Yeah, I think it was more administratively whatnot, but I think he was within his rights.
I will agree with that.
I think that leads us closer to the end. We don't need to, there are a ton of thorny directions this could take in a lot of ways. But if the commission or the Board of Appeals doesn't think the zoning administrator acted in error, then this is a dismissal.
If it didn't act in error, then it's not an appealable offense, correct? And then what would happen then?
That raises a point that I had earlier, or a question I had earlier. Dismissal versus denial.
You want to give us the rundown, Fred?
I think a dismissal contemplates a lack of jurisdiction on the part of the board. Denial is a decision on the merits.
Okay.
So if you find that there was an appeal filed that was not timely, I think that goes to the jurisdiction of the board, and that would be a dismissal. If you find that
Find that no error was made.
no error, then I think that also would probably be a dismissal as opposed to a denial. But I'd have to think on that one a little bit.
Okay. There's-
But the implications have to do with revenues.
Okay.
And no, I'm not an attorney, but there's a phrase called dismissal with prejudice and without prejudice. Is that true? Is that correct?
Well, I don't think that would come into play in this particular situation because there's nothing in the rules and the code that makes that distinction with or without prejudice.
I mean, wouldn't a dismissal imply that the appellant could then turn around and come back and refile the appeal?
If there was a dismissal, that would probably mean that if there were a new appealable determination, appealable decision from the planning administrator, zoning administrator, or planning commission, then that would be subject to appeal.
So conditions would have to change before.
Yes.
Okay.
If, however, there was a determination on the merits and the application or the appeal was denied, then that probably would mean that there would be no opportunity to come back on that because you made a decision on the merits.
Well, dismissal, the appellant could come back with a different argument. Or would that be a new?
Well, it would have to
appeal?
be timely. Have to go through the same analysis. Was there a decision, which is the first question, was there a decision made? Then was there a decision of interpretation? If there was it timely filed? So just go through the whole analysis one more time.
So in terms of where we go from here, I think you got the gist of it, Fred, that any decision that we'd be willing to, three of us would be signing on to would be a dismissal and finding of no error on behalf of the zoning administrator with regards to this case. Is there?
Well, first you would have to make a determination, was there a decision?
Is this like where I want to formally like get us all on the record on this type of thing?
I think we have already decided that.
It was mine.
Yeah, we have officially-
Right, you
Right.
made the decision, or you haven't made the decision because nothing final, but you seem to be a little bit of a consensus that that Chris Jakubiak in 2021 made a decision. Okay,
That's where we are. It's mine, unless someone says differently.
I concur.
then question is, was there an appeal taken from that in a timely manner?
I think this is what Amy was just getting at, which is, I think where we were, which was in order to make an appeal, the wrongdoing would have had to have been made, right? Like,
Had been an appealable
it had to be,
offense.
had to be an offense. So we were trying to figure out if we thought it was an error before we worried about the timeliness question.
Right.
Right. And I think we agreed that it was not an error, or if it was an error, it wasn't in anything in the scope of what we're seeing.
Not a matter of interpretation.
Not a
or
matter of
anything else relating to the zoning ordinance.
Yes.
Zoning chapter.
And then we wouldn't need to get to the timeliness question because we've already decided that there's no appealable error that happened here. Am I missing? I think that kind of,
I think you've got it captured.
okay. Is that enough for you, Fred, to begin drafting?
So let me suggest that I take tonight's discussion, go back and put together a draft of a resolution embodying what you all talked about and any related matters that I may think are necessary or appropriate to go in the resolution, and then get drafts out to the three of you, hopefully in the next week or so, week and a half, so you have an opportunity to review it, before the next meeting on the 31st. And I would encourage you to send any suggested revisions or comments directly to me, not to each other. So it's just it remains attorney-client privilege, and we don't get into issues about open meetings. So and then I'll take and digest what you all tell me and either make some revisions or hold them till the next meeting.
So do we make a recommendation now for your,
I think you've given me guidance. I think the minutes can reflect that. There was a consensus because you're not making a final decision. You're giving me, preliminary guidance.
Well,
Go ahead.
if this case could go further or whatever else, do we want to, okay, but if this is not found to be the case, then whatever. Like, I know just even in this appeal, it was stated, okay, so if you say that the moratorium was legal, then we state da da da. Would we do a similar thing here or no? Because we were saying that if there had been an error, the timing would be such, and that therefore it would not have been timely.
Well,
Do we get into that or no?
In the draft resolution, a portion about timing.
Okay. Cool, thanks.
Right. With that, I'm tempted to adjourn. Is there any other business before the board? Anything talking about? Our next meeting is what date?
The 31st,
The 31st at 6:30.
2 weeks from today, yep.
Weeks today, 6:30. We will get back together to review what Fred's putting together. At this time, I'll entertain a motion to adjourn.
I'll make a motion to adjourn.
A second?
I'll second.
Favor?
Aye.
This meeting's adjourned. Thank you.
Well, that was a short meeting.
Yeah.